Life, Loss and Legacy is a general information podcast only. This does not constitute professional advice as we simply don't know your individual circumstances. If you do have any questions, please be sure to contact the guests of the episode. It should also be noted that the opinions expressed by the guests and host of the podcast are theirs alone and do not represent the opinions or perspectives of their employer or any other associations. That's enough warnings. Let's get started. Hello and welcome back to Life, Loss and Legacy, a planning solo podcast dedicated to helping people navigating those first few years after losing their partner. My name's Jordan Varga. I'm an independent financial advisor with Planning Solo, and I'm joined today by another independent financial planner, Nathan Fradley. Nathan, thanks for joining us.
No worries, Jordan.
Now, I've invited Nathan on today. He is the principal advisor at Fradley Advice. He's an expert in helping people navigating complex estate planning matters, as well as helping people through difficult family law advisory situations and helping people into aged care. He does all of the difficult stuff. So thank you for coming on, Nathan. We are talking today about superannuation and death. More particularly, what does it mean for the people that are left behind? What should they be doing? What are their priorities? What are some of the things they need to be aware of? So, Nathan, we might as well hop straight in, if that's okay.
Mm-hmm.
Perfect. So we'll talk a little bit about, I guess, those first few months after somebody has passed away. So somebody's passed away. The people that are listening to this show will be going through this process and trying to work out what to do. So I'm curious, what do we need to do about their superannuation? So somebody's passed away, the dust is settled. What do people need to do next?
I think the first thing you need to do is work out what superannuation they have. And in a lot of circumstances, that can be really difficult. If one person has managed the money up to that point and they're the person who's passed away, then it can be quite tricky to identify, okay, which super funds do we have? Where are the accounts? Which products are they with? These things change a lot of the time. And how do I start from there?
What are some of the ways people can try to track that down? I mean, the ones that pop to my mind are you've probably got some statements floating around the house. That might be a good place to start.
Always a good place to start if you're getting mailed out statements. All of their accounts will be listed under MyGov because it's linked to their tax file number. And that if they've got an accountant, their tax agent should be able to see those accounts as well through their portal.
So that's really handy. So they can hop in and see whatever accounts may still really have any money left in there at all. They won't say which funds have insurance though, will they?
No, there will be no listed insurances. It'll just say the balance at the last quarter, but at least you'll have an account number and you'll have a product name. And usually, they'll also have a postal address and a phone number as well, which is a great place to start.
So statements around the house, MyGov, accountant, payslips sometimes can be another place if you're really looking hard to try to find things. So
or what hits the bank account as well. If they're getting pension payments, then you'll be able to know, okay, I can see that super fund A has been paying into our bank account each month.
I think it's a good opportunity to flag as well that it's not unusual for people to not know where their late partner's super funds were. So there is a process to follow, and hopefully those tips can help out a little bit. So let's skip forward. We've worked out what funds we have. We've worked out account numbers, all of those details. I've got a little list written down. What do I do now?
You've got to get in touch with them. And this is the trickiest part of all.
Here's where the dread kicks in.
So each super fund will have their own process of which you can gain authority to look at the account. Often there'll be some form of third-party authority form, which is an information-only form that you can get signed and send that in. But those are usually signed by the person whose account it is.
Who's no longer
and
there.
So, without a death certificate and often probate information, you can't actually do a whole lot depending on the fund. Now, what I really want to highlight here is that superannuation is not what we consider an estate asset. So it isn't necessarily involved in probate. And if someone's died intestate without a will, you may not get probate granted for 3, 4, 5, 6, 9 months, a year in some instances. So you don't necessarily, most of the time you won't need that, but you will absolutely need a death certificate. And then it's up to that trustee to decide. The super fund's trustee is basically the those who run the fund, to decide what they will accept as reasonable information to then be able to give out a member's private information to someone else.
And one of the things we'll come back to, because there's sort of the third area I want to talk about are tips and traps, because the trustee issue can be really problematic. That's where a lot of the problems and the delays you hear about are normally at that level, if we can generalize. But so they'll each have their own set of requirements. They'll each require a death certificate. Normally, you need to substantiate your relationship to the deceased as well, I think. So a marriage certificate or something like that.
Correct.
You have to ID yourself. Often these need to be certified. Sometimes they need to be with a wet signature rather than a did. There's all these different variables. So each fund, you might have 3 different funds with 3 wildly different approaches. But ultimately, it's about proving who you are, proving that the member has passed away, and giving them the material to actually release the funds.
So what I'd say in this instance is the same with all bills. It's the same with the bank accounts. It's the same, a major part of this process. A great tip is to head down to Officeworks and print off 50 copies of your driver's license, and then find a really friendly JP or police officer and get them to certify. Yeah, get them to certify as many documents as they themselves are comfortable and that their pen hand can handle. Because you're going to need copies of your ID and the death certificate, and what effectively they'll be trying to identify as next of kin. So if you're the spouse, that process is much, much easier. If you're married, it's easier than if you're de facto. But effectively, they're trying to figure out, who are you to this person, and are you the person they should be speaking to? The reason it's more complicated, with super, is that it's not the executor doing this. The executor has a very clear title that will be done through the will. If the superannuation is not going to the will, then, or we're not going as per the will, then it's really up to the super fund to decide on these matters.
I think it can get really complicated with that, but I like that kind of procedural tip of have a stack of IDs certified. Like, you don't learn this, I think, as part of this process. Like, you learn this by experience. So if we can shortcut that, at least by just get a stack of licenses signed, even death certificates as well, just to make the process a bit easier for you.
It's usually what I do when someone comes in this instance. I get them to bring in those documents, and we print off 10 copies, and I'll certify 10 and send them on their way. At the very least, they've got something behind them.
Yeah, it just helps with the process. Because if we can minimise the process pain, it should hopefully alleviate a bit of the stress. So you've contacted all the super funds. You'll let them know. Let's say that, yep, I agree, you're the person's next of kin, we will deal with you. Next step, I would have thought, is confirming who the beneficiaries on the fund actually are.
Correct. So beneficiary nominations are really going to guide this entire process. And a beneficiary nomination is effectively a document or a declaration that says, in the event that I pass away, this person should receive my money, these people should receive my money. And it is done by the person whose super fund it is. It is not done by anyone else. It's not drafted by a lawyer or anything like that. The form itself will always be managed by the super fund. And effectively, it's an instruction to the trustee. And the trustee has a responsibility. And it's quite an interesting thing compared to, say, a will. If you've got a binding death nomination in place, that first word is really important, binding. It means it's legally binding. If it's a valid person, I'll speak to in a second, then the super fund has to follow it.
When you say binding on the trustee. Yeah.
Yeah, so the document will be called a binding death nomination, and it is legally binding on the trustee that they followed what this says. And there's been some really interesting cases where there's been, mistresses or what have you that have received the money from the superannuation and have been able to substantiate that they are a valid beneficiary. And this can be really tricky. So I think, a good course of housekeeping is to check the beneficiaries and make sure that they are people who are eligible. So that can be either a spouse, they don't have to be married. It could be children. They don't have to be of a certain age, but there is tax implications over a certain point. Or they are financially dependent or interdependent on the member. And those last two are very difficult to prove. And I wouldn't rely on them, to be honest. We've seen some really interesting cases where what you would think would be perfectly reasonable just hasn't gone through.
So I think it's worth spending a little bit
So,
of time on this because it is a very complicated part of superannuation in general, and it kind of sits in that weird middle area between what we do and what solicitors do, like the will side of it. So the beneficiary nomination. So there's two hurdles that people need to clear. So my understanding is the first one is, can they actually be paid the money out of the super fund, which is what you're talking about there: spouses, children, interdependency relationships. There's a fourth one. What was the fourth one?
it's dependent or interdependent.
So that's, can they be paid? And then the second hurdle is, if they are paid, what tax consequences are there? So can you just run through maybe of those 3-4 categories? What are the tax consequences for each?
Yeah, sure. So for a spouse, there is no tax consequence at all. So the tax consequences, I think, can get a little confusing. How detailed do you want me to go on this, Jordan?
Let's talk about the differences between dependents and non-dependents, and let's ignore untaxed funds.
Great. Okay, so what you'll find is within your superannuation, there'll be what's called a taxed portion and a tax-free portion. And those two, so let's call them labels. Labels for, consider you've got your two pasta containers in the pantry, and you've got a label in front of the two of them. That's kind of how it's two pools of money within the fund. They don't affect the day-to-day operations of how you are, if you're on a pension, how you are paid from that, and how that is taxed if you're over 65. But what they do when it comes to paying out in the event of someone passing away is the tax-free portion is tax-free to anyone who receives the money, but the taxable can be taxed. And this can get a little bit problematic because most of the time we find out things aren't done ideally after the fact, and there is no fixing them for obvious reasons. So a taxable amount is taxed at, basically it's taxed at 15% plus Medicare is the simplest way to describe it. For people who are not financially dependent. And the way they define that is spouses. They just immediately get that exemption. Children under the age of 18. And if you can prove financial dependence.
Which, as you say, is a very extreme and very difficult sort of test to pass. But I think this speaks...
I got check that and delete that if I'm wrong there. I'm very sure I'm right, but dependence piece.
Yep, okay, cool. We'll hop back in.
So that changes what's released from that money, but only the taxable part is taxed. So an example of that is, let's say I have $1 million in super and 700,000 of it is tax-free and 300 is taxed, and my money goes to my adult children, then only the 300 will pay tax. It'll be 15% plus Medicare levy on top of that. And the rest of it won't be. Now, where this can be problematic is that if the children do receive certain benefits, like childcare benefits from the government, this can be considered income for the purpose of those things. It can actually knock out certain benefits. It can affect child support. It can affect a range of things. So there is a bit of complexity to this. Is that the case
if it washes through the estate? But then...
No. So the estate receives that as income, and then allocates it accordingly. And depending on how your will is constructed, there are clauses that you won't be covering in this episode. I'm sure you'll cover in another, that you can put into your will to allocate things as tax effectively as possible while mitigating.
And one of the themes of the episodes recorded so far has really been, this is not an area where you want to rinky-dink it. Like, you want to get specialist advice, particularly if you have anything above, a tangible amount of money. Like, you want to get special, because even in this case, I'm thinking, what if you had kids with a 10-year age gap and one of them was approaching that point where they were independent? Like, that's going to have consequences. Like, all of these things need to be discussed with a specialist, probably a team of specialists, because I know solicitors always feel a bit uncomfortable giving advice around this too.
Yeah, and that's just straight payment of money. Then you've also got the ability of how you pay that money. which I
We'll come
think
back.
is the other side of this.
We'll come
So
back to that because I do
if
want
you're
to tackle the different
if
schemes
you're
because there's a few. But just while we're still on the mechanical piece of getting the money out of the super fund, so you've confirmed who the beneficiaries are, then you have to get the paperwork prepared around that. How onerous can that be?
it's not. I say it's not particularly onerous, having dealt with much more onerous procedures with super funds. Everything is onerous when you're going through this process because dealing with paperwork is the last thing you want to be doing. You've just lost your spouse, and everyone's asking for the exact same information you've already given. So if you've determined there's a superannuation amount and and then maybe there's some insurances, there is potentially 2 claims, depending on the structure of how they're set up, that you've got to make. So you're making a death benefit claim. Generally, it's called the same thing when you're accessing money from a super fund as well, twice. But the first thing you want to do is understand, is there insurances and which fund owns the insurances? And this can get a little bit trickier as well, because if it's a group super fund and the cover is held with that fund, I've got like an industry fund or a not-for-profit, and it comes with default insurance, or you've modified the insurance that it came with, then that super fund owns that policy. The proceeds are paid into that fund. So you don't want to do anything with that super until those benefits are paid. If you've got a super fund, some of the retail funds have the exact same thing. You might be around for quite a long time, and you've got a retail fund that owns some retail insurance that does the same thing. So the important thing is like who owns it. There is also a different way of holding insurance where there is effectively a super account that has 0 fees, 0 investments, and just owns the policy. And every year there's a rollover that goes into it. That account has to receive the benefits, and then you can look at what do you do next? Do you move them into the main super fund, or how do you allocate it from there? And they'll often have their own beneficiary nominations as well.
I think thank you for going through that process, because it is a multi-step process. You are not going to call the super fund on Monday, have the money by Friday. So you're applying to the super fund, but also in the background as an insurer, like you say, that money has to land into the deceased's account, and then it comes out. And there's a lot of complexity around that. And frankly, I don't know how people do that on their own. I would be getting a financial advisor to help me with that. And even that, you're looking for one with experience and that specializes in this space, like you do, to try to help navigate that, because it isn't easy. It's quite complicated. Okay, so the money's in the account, the money's been paid out. How is that paid out normally? We're really trying to drill down to the fundamentals here. So
yeah, so you'll lodge a death benefit claim form. They'll have slightly different names, and this is mechanically what's going to happen is you've got to provide, as per the form, the evidence that person has passed away, and the trustee receives that information and they process that information. This is where super funds differ enormously. They'll differ with how that they define their rules with you, but they also differ with their processes. So there's super funds that generally, the lower the cost of the fund, the less resources they're going to have to deal with things that they may not have to deal with a lot. So if you've got a fund that is predominantly used by younger people that aren't necessarily in retirement phase, that are mainly accumulating money, they're not going to have the systems, processes, and probably experience to do a lot of death benefit claims versus funds that may have an older demographic for an employer that tends to have older people in it, or maybe more expensive products that hire people for these kinds of things. So that can shape the turnaround times, because the trustee has to sign off on any release of benefits to anyone. So if it's a disability claim, if it's a death benefit claim, if it's a terminal illness claim, the trustee has to sign off on it. And there's super funds that do that on a daily basis. That there is a process trustees are actual people. There is a group of people that have to look at something and say, do I have the information? Does this follow the process that we've a business agreed to meets our requirements, which are enormous? And if they get this wrong, they get in a lot of trouble. And can I sign off on this? So I've dealt with funds where they meet once a month. So you could lodge the form the day after they met, and you've got to wait a full month before they will look at your forms.
The regularity of their meeting, there's nothing legislated or regulated around that. It's just whatever works for them. I have heard of some that are quarterly, which it blows my mind, but I think
whatever's their structure,
or at least monthly, surely.
Yeah, yeah. I would suspect their best interest obligations on a quarterly basis might have them look at death benefits a bit more frequently because they do have to act in their members' interests. So I think that they would be less. They may have certain things they look at quarterly. I wouldn't suspect death benefit would be one of them. But there are some that will do it that day or the next day. I've dealt with funds that have teams of people whose sole purpose it is to assess this, come back to you when something is wrong and say, hey, this is not clear. Can you make this tidier? You didn't attach that page. You've scanned the document, but you forgot to scan the second page of all of the pages. And they'll come back to you within the hour. So it really, that your experience is going to vary greatly on the fund that you're with, the resources they have, and then the experience of the people who happen to pick that up. Like anything, you could get one person who's done them before, that person that everyone seems to get every so often at a call center who just knows everything. Or you could get someone who's it's their second day.
To make, because the ABC in particular, I think in the last 18 months has been putting a really strong focus on this issue with some particular funds that are causing a lot of hassle. But for people about to go through this process, it is worth noting that's not necessarily going to be your experience. It is very fund dependent and individual dependent, but just understand that this won't be a quick or immediate process. It can be a little bit dehumanizing. It can be a little bit confronting. But most of the people you'll deal with in the super fund, they're humans. Like, they're going to hopefully treat you pretty well, but they can get a bit overwhelmed. So the forms are lodged. Sorry.
Yeah, and I was just setting expectations there as well. Like, knowing that this can take time, it's just setting yourself up for that in itself. Secondary to that, I've not actually had a bad experience with anyone at a super fund who worked in the death benefits team. It's a particular kind of person who needs to be in there with a certain level of empathy to go through these processes. So they've got to stick to their rules, but they're generally quite good to deal with.
Okay, so it's all been approved. Trustees have had their monthly meeting. They've signed off on it. Then they release the money. That's paid out via like a direct deposit into the nominated bank account. Is it a check that comes out? Is it a...
Well, I think there's a couple of things we've probably got to touch on before this point, because we've assumed that there's a binding death nomination in place. The trustee has clear instructions of where to pay it. The trustee looks at that and says, yes, this is correct, and they can't do anything about it, and they pay that money. If that beneficiary is binding, but it has someone's sibling there, the trustee is going to look at it and say, this is invalid. And they throw it in the bin. It is that piece of paper does not matter anymore. And then they will have to make a decision as to where that money goes. The same can be said to if you haven't got a binding death nomination. So what often happens is you might have put one in 4 years ago, and after 3 years, most of them will expire. And so it'll change. It'll say, I'm giving it to my spouse, and now it's non-binding. The super fund does not have to give it to the spouse if it's non-binding. Complete discretion at that point. I'll give you an example of where that's played out in some work that I've done. Young father in his 40s. They'd separated about 18 months before, and he never updated his beneficiary nomination. And he still had his ex-wife on there as the nomination. They had 2 children, shared custody. The super fund decided to leave it to the children in trust, or leave it to her as trustee for the children. And I've never seen a super fund make that level of detail in a determination. So they've effectively said the children aren't old enough to manage this money, so we're going to leave it to the mother to manage it for them, and when they become 18, it automatically passes to them. And that was an industry fund, which generally won't have the resources or the flexibility in decisions. So that was something that really I was quite impressed by, because it really helped guide what they could do at that point.
For anybody listening, this is a good piece of kind of regular financial hygiene, is just make sure you've got that in place with your super fund. It should be on your statement that comes out, or if you call them, just check, updated. Make sure that they reflect your wishes at all times, because otherwise it gets a bit too hairy. You've got the nominations, you've got binding, non-binding, lapsing, non-lapsing. It's going to dependents, non-dependents. Like, it's a very complicated mix, and I'm sure the people listening have been bombarded with some of this terminology, so I'm glad we could address it a bit. Anything between that and then the money kind of landing in people's hands?
Well, you mentioned lapsing, non-lapsing. So, just so a normal binding death nomination will lapse, as I said, in 3 years. Some funds will let you have a what's called non-lapsing, which means that it doesn't lapse. Once it's nominated, it's in place. This is really important if you're either older or the person who's superfunded is at risk in certain ways. So if they've got cognitive decline or any form of disability, where they may have their cognition now, but once they lose the ability to make decisions, they cannot update these. So just something of note, depending on your situation, just to take heed of.
I mean, even just talking about it, it's second nature to us, but it is so very complicated. And I keep thinking of the people listening they've had this thrust upon them and now they're having to deal with it. Money hits their account.
So what happens now that when the money's paid out, what are your options?
I guess what I'm trying to, is that paid out as a check? Is it paid out as a direct deposit normally?
Yeah. So once you've got the sign off that this person is in fact passed away, the money in the super fund becomes what's called unpreserved. And that is, it's not preserved. You can access the money.
Terminology.
Not restricted, not preserved is the formal full sentence. Yeah, they just really like layering on complexity. But what that means is that the money can be accessed at that point. And it has to be accessed in accordance with the beneficiary nomination and the rules of the trustee or the rules of the super fund. So then we're adding more complexity in here. So we know that this person's passed away. We've got sign off from the trustee. They're going to want to know. They're going to say, okay, what do you want to do next? So you can take a lump sum and receive the money. As we said, if you're the spouse, you'll just get a lump sum of money. If your spouse was in pension phase, they had a pension set up, you're already retired or they're retired and they're receiving a regular income, they could have set up what's called a reversionary pension, just to put more complex words in, which means that if they've nominated you as their reversionary beneficiary, their pension will just keep paying to you and you don't need to do anything. Nothing changes.
Benefit payment has been approved, which there is in the legislation. It has to be as soon as practicable, I think. As soon as it's approved, I mean, I would be pushing people to get financial advice because you do not want, like, maybe there's a reversionary payment, maybe it's a good idea to keep that, maybe there's not. You just don't know. Your circumstances may have changed from the original plans. But so you can get the money paid out as a lump sum to you directly. If you are a non-tax dependent and you're up for that 15 to 17% tax that Nathan was talking about earlier, sometimes super funds will withhold that, sometimes they won't. Like, you need to be conscious of that. Okay, so you've got the reversionary payment, which can be quite good in a sort of spousal relationship. Are there any other sort of pension options that can apply to a super death payment?
Mm-hmm. Absolutely. So people, first of all, they grab the withdrawal form, they get the money paid out to them, they go, cool, I've got this money. I would say if your spouse passed away, go speak to an advisor immediately, because we've already laid in so many pieces of information that could be that even just just to have someone go, this is these things. They can give you factual information. They don't have to give you advice. Just speaking to someone can take away some of that strain and stress. But then it also starts setting you up for some different options. So one of the options you've got is what's called a spousal pension, which means that if you are the spouse and the beneficiary nomination is to you, then the super fund can be moved to a pension account and start paying you an income. And as that money is a death benefit and you're the spouse, it's tax-free. So this can be really effective when you start looking at why we have insurances and who's providing for who in income situations. And if you've got a family where an income earner of the household has passed away and they've got a lump sum of superannuation and insurance that's paid together, this can help replace their income to the household in a tax effective manner. This is really useful. There's also what's called a child-based pension. And the example I gave before was what we discussed with this particular client. The problem was the fund that made a fairly well thought out and complex decision couldn't actually do child-based pensions, which is not uncommon. There's actually a lot of funds don't have them. Most don't, actually. It's not even more. It's most don't have that ability. So when you're in that situation, you can actually change super fund. So you can move this money from point A to point B into a different fund that can do a spousal or a child-based pension if that's what you need to do. And this, you'd be absolutely getting advice when you're getting to this level.
About today is stuff that you should be acting on. What we're trying to do is highlight the complexity, highlight some of the tips to help you navigate it yourself. But ultimately, the message is go and get professional financial advice, because this is pretty hairy. And if you get it wrong, the consequences can be big. I mean, if you're getting $1 million payout out of a super fund and it goes to, quote unquote, the wrong person, it's potentially 170 grand of tax that's going to come off the top of that. Just bluntly.
Yeah. And also, one of the people or the person listed as a beneficiary could be the legal person representative or the estate. And that means the money just goes to the will. It goes and forms part of that pool.
Insurance payments out of super are not an estate asset. Can you, I guess, walk us through what that looks like then for a beneficiary and an executor when they've got these two different streams of money coming into the post-deceased life?
Yeah. So if you've got nominations on your superannuation fund, the executor of that will and the estate and anyone who has claim on that estate
it's none of their business.
Can't care about it. Is probably the best way to put it. It does not exist as far as they are concerned. And I've seen this a number of times. It's the same as a family home. If you own a home together with someone in joint tenancy and one of you passes away, the other person just owns 100% of the property. And I've seen situations where, in split families where the children of the passed away person have come out and said, well, I want the home. I deserve it. And it's like, well, it doesn't exist as far as you're concerned. It is not part of the estate, and neither is superannuation. And I think when you're looking at how you set this up, this is really important from a fairness and equity perspective and an estate balancing, because sometimes people go, I'll leave my estate to one person and my super to the other, and then everyone gets the same amount of money. But what happens is the super pays to that person, and then they have zero distribution from the estate and could have a claim. And therefore your wishes don't end up being enacted. So I think this is where it's really important to, again, working with a financial advisor and your solicitor, or talking through the beneficiary with your solicitor when you're doing your will, is that how this happens is directed far before the event. And once it's happened, it's already happened. But yeah, as a non-estate asset, it doesn't appear in the estate at all. This can also be an effective way if you've got any particular bad blood in a family or a situation where maybe you've got a child that you no longer associate with and two that you do and want to care for, that you can pass your superannuation without it being included in the estate. It cannot be challenged. A binding death nomination has to be paid as per its nomination. It cannot be challenged.
I had some reservations around recording this, because I thought the people that are going to listen to this, they kind of had this dumped on them. They're dealing with the consequences of what may have been poor planning beforehand. And we'll be doing an episode down the track about how do you deal with that legacy when the person that's passed maybe got some things wrong. But I think hopefully we can help with the mechanics of it, but also for their own affairs and making sure their own stuff is structured well. Hopefully that can help with that. In terms of sort of the tips and traps that can arise with this kind of thing, I think we've covered a lot of the ground already. But one of the things that popped into my mind, just to get deeper into the weeds here, say the person who has passed away was ill for a while, perhaps had a terminal illness or perhaps they had a permanent incapacity. Can you walk us through some of the options you have to maybe get money out of super before they pass away? Again, touching very generally. We're not going specifically here. Anybody listening?
So there's several conditions of release to access money from your super, what they call conditions of release, and they're extremely strict, and the trustees have an enormous responsibility to uphold those rules. One of those rules is terminal illness. And so if you are terminally ill and can prove that, you can go through a similar process to a death benefit claim, and basically you need 2 doctors' sign-offs, usually, with one of them being a specialist, usually, and someone needs to say you're only going to live for 24 months. which is a pretty heavy thing to go through, to be honest, and most people won't approach this. But it can be easier than a death benefit claim because the person, if they've still got capacity, is signing things instead of having to prove a next of kin or who the authority would be. So that is sometimes a way to, to plan, take money out of superannuation and start paying off debts beforehand, which makes it easy for executors or to rebalance estates, all those kinds of things. But I think I would be very hesitant to do anything like that without substantial consideration to a very broad range of potential implications. So I think, it's very complex and meeting the definition is quite difficult.
If you get it wrong, the consequences are quite severe. One of the things that pops into mind, hopefully people listening have listened to the episode we did with Kelly Gatehouse, where she talked about how life insurance proceeds are treated through an estate and whether they can be used to clear debt and kind of the bleed over with that and super death benefits now as well. There's some question there. You really want to be dealing with specialist advice in this kind of space when you're dealing with anything like this.
There's also a question, and this is a very grey area for advisors, around tax avoidance. And so a common thing that's discussed but can't really be done is if you've got non-tax dependents or adult children and you've got a lot of money in super and you want to give it to them tax-free, if you're terminally ill and you're going to pass away in the next few weeks, you just pull it all out of super to avoid tax. If that's why you did it, it can be considered tax avoidance.
And I feel like there's
which is awful. It's just like
because it is quite like payout and lodgement and things like that. And I think it's also one of the ways we know each other is we have a podcast we do
awareness.
Challenge the Standard. It's very nerdy, very much just for advisors. But one of the things we talk a lot about there are the ethical questions as well, because in the instance that you've just outlined, the client isn't benefiting materially from that or quantifiably. The children are. So how can we necessarily advise around that? It gets very, very hairy, and I think you want to have a really good advisor who wrestles with some of these things to give you... There's very little black and white advice here, I think. There's always nuance.
Because of this, because of the requirements around trustee responsibilities from a super fund perspective,
and they take it very seriously.
They've got some really strict rules, and so they don't mess around.
They are taking their responsibilities really seriously. Nathan, we've covered everything I wanted to cover, and I feel like we've covered about 30% of the actual topic. So if people do have any other questions for you, where's the best place to reach you?
I mean, like LinkedIn or reach out to Jordan and he'll be able to introduce you to me.
That is Nathan's business is
that's probably the two best places.
In that he works with other advisors to work on specialist cases that may apply in your instance. So if you do have any complexity around your estate matter, if you do have any complexity, if you're in the family law space or anybody you know does, reach out. I'll pass you on to Nathan and he'll be able to help you out. Any final thoughts, Nathan, before we wrap up?
I think it's just really important that hygienically you keep up to date on this, that your beneficiaries are accurate, that they are either a spouse or children, or they go to your estate, that you think about those things in line with your will, and that if there's any inkling of future or serious illness where there could be a future death in a relatively short period of time, that you really start thinking about the structure of these things.
Conversations is, I think you can't really have a set and forget estate plan. Like you should be reviewing it every couple of years because life changes, things change. But Nathan, thank you so much. Thank you for your guidance and your help around this, because hopefully it has helped a few people with the procedural aspects of dealing with superannuation following the loss of their partner. We'll wrap it up there. My name's Jordan. Thank you again for listening to Life, Loss and Legacy. As always, if you have any questions, you can reach out to me at jordan@planningsolo.com.au. Otherwise, until next time, I'll see you then. Cheers.